Recording in progress.
Good morning, Buhle. Are all the stakeholders in the platform and do we create as a committee?
Morning, sir. We don't create as yet as a committee. But
How many members are in the platform?
4.
We have 6 members on the platform.
Oh, okay. I didn't see the other 2. Okay. I didn't see the other 2. Sorry.
Okay. Where are we? Here we are. Let me welcome members of the Standing Committee Finance who are in attendance. Welcome the stakeholders who are here to make submissions on the tax bills. Treasury, SARS, the support teams to this standing committee, and the public and everybody who's in attendance. You are all welcome. The meeting is officially open. Today's meeting is for the members of the public stakeholders to make submissions on the draft 2024 tax bills. How much time are we allocating each stakeholder, Sister Tebuko?
We're giving them 10 minutes each.
Okay, 10 minutes. Do we have apologies?
The apologies are Mr. Swart, Mr. Lekhanyane, Mr. Sekwati. Yes, those are the four we have. Miss Galeka.
No, okay. Okay, let's proceed and note those apologies. Move to the next item, public hearings on the draft 2024 tax bills. I'll request the stakeholders to time themselves. We have got an associate member here who's going to be the first. I hope it's Comrade Matthew. He understands the rules of this committee more than many other people. So he is going to lead by example. Comrade Matthew, are you there?
Morning, Chair, morning, members. Yes, we're here, and we're slightly intimidated by the chairperson's appealing to us to behave.
Okay, no. You're welcome, Comrade Matthew. Over to you, 10 minutes.
Okay. Thanks, Chair, and we'll just upload our document quickly. So, Chair, we would present on two bills, on the Revenue Laws Second Amendment Bill and the Taxation Laws Amendment Bill, but just focusing on very specific points to them. We do welcome the opportunity to make our presentations, Chair, and we appreciate members giving us space. And, as COSATU with the Sixth Parliament, we have been deeply involved in the two-part pension reform discussions. And we do welcome the very positive progress we made on that front. But we think on the RLAB, there is 4 areas we think should now begun to be addressed, urgent areas. And these were extensively discussed, Chair and members, during the Sixth Parliament, also with Treasury and in the extensive parliamentary hearings that SCOF had held during that stage. We had a general understanding with Treasury that they would be resolved once the 1 September implementation had been rolled out, which it now has been. So we're a little bit disappointed, Chair, because they had also made a written submission to Treasury on these issues for the RLAB. There's no reference to them. And we do think, Chair, these are substantial and urgent matters, and they should not simply be delayed. In essence, Chair, they cover 4 issues for the RLAB. The issue of workers losing their jobs, the issue of vested rights, the taxation rate for low-income workers, and possibilities of education loans. Chair, and then on the taxation bill, TLAB, we're a little bit disappointed, Chair. Not a little bit, we're disappointed that, despite government's commitment in 2018 and 2022, and even more recently in the opening of Parliament address by the President in July, that there's no reference to the reviewing the fuel tax regime, as well as the basket of goods exempt from VAT. In fact, Minister Matashi made a comment about that yesterday too, on the need to do so. And even when we had discussions on the VAT, when the VAT was raised to 15% in the Fifth Parliament, there was in the SCOF resolution an agreement that these things must be reviewed in the Sixth Parliament, etc. And I think the context, Chair, is that workers are drowning in debt. They're struggling to cope with the rising cost of living. And government has made a very progressive commitment to review these fuel tax regimes in the basket of goods exempt from VAT. But we do think we need to have a discussion and see what can be done. Then, Chair, just going to the RLAB, to the 4 issues we wanted to raise. The one issue is taxation. So I think members would know that workers, especially low-income workers, are really aggrieved at having to pay tax on the pension withdrawals, especially the ones off relief. Workers do feel that government is, in essence, by default, profiteering from their indebtedness, their misery, etc., which really is caused by a stagnant economy that workers are not responsible for. Pension funds, are workers' deferred wages. And I think we should also remember the point of the two-part reform is really to try to see how to reduce the workers' indebtedness whilst also boosting savings. So we think there is a need to see if we can reduce taxation for these withdrawals for low-income workers. So our proposals, Chair, we've thought 5, and we know it's not an easy thing because there always is a ripple effect when you play with the taxes, and we appreciate that fiscus is severely constrained. But we flag 5 possible options to consider. Could we look at no taxation early withdrawals for low-income workers or those who are below the income tax threshold, below the 96,000? Could withdrawals by lower and middle-income workers be prohibited from pushing them into the next tax bracket, which is one major fear? Or could we look at the first withdrawals by low-income workers being tax exempt, or withdrawals below 30,000 being tax exempt? Or could we have a lower tax rate for withdrawals for low-income workers? For example, 10% as opposed to the PIT rate. So just the options we think, but the point is to see, could we lower the tax burden on low-income workers? On job losses, Chair, under the previous law, if you lose a job, whether there's retention, dismissal, resignation, you have full access to all your savings. So under the new law, you'll only have access to the preservation pot when you retire. You would have access to your vested rights and to your savings pot. We had made the point to Treasury, and I think we raised in the previous Parliament, if a worker has lost his job, he's been retrenched, it's not his fault or her fault. You should not have a situation where the worker might have R1 million in his preservation pot. He's now going to lose his house because he's got no salary. And in this economy of 42% unemployment rate, he's not going to find a job in the next 2 years. And the UIF has got many issues. It doesn't cover everybody, etc. And there's lots of problems with it. So a proposal here, Chair, is that you can't sustain that scenario. We think this is an urgent matter that must be resolved, and basically to retain the status quo that if a worker is retrenched or dismissed, they should have access to the preservation pot. So that's our proposal in that regard. We accept that you need to remove the resignation issue. On the vested rights pot, Chair, one appreciates the 30,000 Rand up to immediate relief is not enough to really make a dent in most workers' indebtedness. So, Chair, our proposal here is that, look, we need to allow workers a little bit of a large amount. We did appreciate the need to take it one step at a time. And we do appreciate the need that, pension funds are nervous about too much depletion of funds and resignations, etc. So we think, Chair, there is a need for a fair compromise on the vested right pot. And our essence proposal is that allow workers the right to choose. They don't force anybody, but just allow them to choose because each person's circumstance varies. To transfer monies from the vested right pot to the new 2-pot regime should be voluntary, and it should be based upon the 2/3 formula. The 2/3 would go to the preservation pot, which would be you would have access to it when you lose your job or you retire, and a third would go to the savings pot, which you could access once a year or when you choose, in essence. So I think that would benefit the pension funds because you would be boosting more savings by having a large amount injection going to the preservation pot, but also you'd be giving substantial relief to workers through access from the savings pot. Here we're just given a kind of simpler formula, but it speaks to that same point. So we think that would be a win-win thing because if you transferred 3 Rand, 2 Rand must go to the preservation and 1 Rand must go to the savings pot. Chair, under the current law, you can use your pension funds for home loans, for collateral, etc. We think we should also have a similar regime for education. Investing in your education or your child's education is an investment in their career, the earning potential, their retirement savings. It's not a luxury, not a reckless investment. So we think that also should be considered as well. And then, Chair, just on the TLAB, so 2 points. We have had this discussion about the fuel price regime. When Jeff Gadebe was minister in 2018, he made a commitment by 2019 there'll be a review. Last year, Minister for Finance, Godungwana, made a similar review commitment as well. President made it in the opening Parliament address in July. And of course, there was similar commitments by the 5th Parliament about the basket of goods exempt from VAT, and the President also made that point now. But the reality is, Chair, if you look at the NCR reports, workers are drowning in debt. And inflation hits workers much harder than it hits everybody else. Your Eskom 18% electricity hike last year, maybe 33% next year. The transport, fuel prices, etc., have all gone up significantly above inflation. workers are really struggling, and you've had a repo rate hike of over 400 basis points over the past 2 years. So government has made these progressive commitments. We appreciate it's not an easy thing because the state is under severe pressure. There is a reduction fund, etc. But we think there is a need to honor this commitment. We've had discussion in NEDLAC for the past 2 years on it, and we've really found that Treasury has not been keen to engage at all. So our proposal in this regard, Chair, is that Treasury should return to NEDLAC. Let's engage in good faith on both the fuel tax regime and the basket of goods exempt from VAT to see how to give relief to the workers, to the economy, whilst appreciating the real fiscal constraints on the state. But we think there is some space to do so. So, Chair, in conclusion, and apologies if I galloped a little bit, but I wanted to try to stick to the time frame. We do hope our proposal would be considered by SCOF, by Treasury. We think they are really urgent and important. They shouldn't just simply be delayed or dismissed by Treasury. We think at least some of the RLAB proposals around the two parts should be definitely considered for next year implementation, especially the issue of workers losing their jobs and having access to the full savings, and even the issue of vested rights transfers. At least we can prioritize those two. For next year, we can look at the other ones for the year after, but we should have a discussion. These are not new issues, Chair. The members, we had raised them extensively during the very many hearings SCOF had in the 6th Parliament, as well as with Treasury. The Select Committee, Chair, just before the elections, also specifically raised the issue of taxation and actually specifically mandated Treasury, if memory serves me right, to revert back on the taxation issue as well, because I think there was a lot of uncomfortability there. Of course, one appreciates the pension fund regime is built upon tax incentives to save and tax disincentives not to withdraw, but we do think there is a need to have a discussion to see what's possible. So, Chair, yeah, so we think, Chair, these proposals are engaged, expedited, and resolved. We're convinced we can achieve a consensus between government, industry, colleagues at CISA, etc., ourselves, Labour. We think we can find a win-win solution, but we are requesting urgent engagements to resolve them, especially because the tax year is around the corner. Even if it means we have a start implementation date of 1st of September next year, that's fine, but at least something next year. We do think there is a need to expedite the review of the fuel price tax regime and the basket of goods exempt from VAT. The DJ Murray Trust Chair, which is a progressive NGO, has done excellent work on this issue of essential goods for nutrition, etc. We can ask them to share with SCOF if they haven't previously, because I think that would also be quite useful information, Chair, speaks to issues of poultry, etc. But again, to see how can we bring this issue to conclusion. But again, Chair, we think these are really critical poverty alleviation interventions, and it would be worthwhile for SCOF, for Treasury to pursue them. But we think it would benefit the economy, would benefit workers, commuters, businesses, the pension funds, etc., etc. So, Chair, I think I've just hit the dot on the time. Let me stop there, Chair, and thanks, members, for giving us space to share our views. Thanks very much, Chair, members.
Thanks very much, Comrade Matthew, for leading by example. As you have said that you use exactly 15 minutes that were allocated to you. Thanks. The next stakeholder, World Health Organization. Over to you, 10 minutes. We only see the presentation, but we can't hear the voice behind the presentation.
Sorry about that. I didn't unmute myself. My apology for that. I'm Eugene Mahlehla from the World Health Organization country office here in South Africa. And thanks for the opportunity to make this presentation to the standing committee. Chair, there's colleagues of mine that would have been with me, but they are not able to join. So I'll do the presentation on behalf of the team. I'll put it now on presentation mode. Our comment is mainly based on the draft rates and monetary amounts bill. We focused on tobacco as well as alcohol, and a bit on the SSB tax, the health promotion levy. On the tobacco products, following our review as proposed for 2025, there is an increase of about 4.7% in cigarettes, as well as 8.2% in cigars and water pipe and other pipe tobacco compared to current rates. So the increased proposal for cigarettes are just at the level of or slightly below the current inflation rates, with average rate of about 5%. And we feel that since the cigarettes are the most commonly used products, and in order to effectively reduce its affordability, while at the same time increasing revenues, it is recommended that tax rates for cigarettes are increased above the inflation rate, and that is above the current inflation rate of about 5%, an increase similar to or above the increase proposed for other tobacco products at about 8.2%, which would yield a better health and revenue benefits. So for WHO, we therefore recommend a tax increase of about 8 to 10% of cigarettes. On the other tobacco products, which is the heated tobacco products, the current structure of excise applied on heated tobacco product is in line with the WHO's recommendation to tax on heated tobacco products, that is, to apply a specific excise on the basis of sticks similar to cigarettes. However, the rate applied to HTP is about 75% of the cigarette excise rate. HTPs contain tobacco and should be treated as tobacco products. Decision 22 of the WHO Framework Convention on Tobacco Control, Conference of the Parties, recognize that heated tobacco products are tobacco products and are therefore subject to provisions of the WHO FCTC. In light of this decision, WHO is recommending that the excise tax rate applied on the HTP should be the same as the rate applied on cigarettes. On other products as well, the electronic nicotine delivery systems, with regards to these products, WHO welcomes the introduction of an excise tax on those products. That was in June 2023. The proposed rates for 2024-2025 are also suggesting an increase of about 4.8% in the next budget, just close to the current inflation rate. Given the affordability of those products, and in view of the alarming rates of consumption of electronic nicotine and non-nicotine delivery systems among the youth, and the increasing evidence that the use of those products is becoming a gateway to cigarette smoking, current excise tax rates on those products needs to be substantially increased, well above the suggested 4.8% and well above the tax increase on cigarettes. In parallel, enforcement needs to be strengthened in order to guarantee excise taxes are paid and reflected in the market retail price. WHO also recommends that the tax be applied equally to all delivery systems, whether or not they contain nicotine, for ease of tax administration, and based on evidence that many e-liquids labeled as nicotine-free actually contain nicotine when subject to lab tests. On sugary beverages, while no change in the rate of the health promotion levy on sugary drinks seems to be proposed, WHO recommends that the rate be regularly increased above inflation to reduce the affordability of sugary beverages. And as initially considered by the government, WHO recommends that this levy extend to all beverages that contain free sugars, including 100% fruit juices. On alcoholic beverages, WHO firmly advises that, along with other alcohol control measures, countries raise alcohol taxes sufficiently to reduce alcohol-related harm. The type and structure of the tax should be adapted to each country's specific needs and institutional settings. It is noteworthy that the beer consumption in South Africa is disproportionately concentrated among lower income groups who also bear the most significant alcohol-related health burden. And indeed, in the South African context, the latest industry financial report indicates double-digit revenue growth and record high sales volumes in the beer market. Therefore, it is crucial for South Africa to promptly address this issue, with excise tax policies playing a key role in reversing the troubling trend of rapidly increasing beer sales. Given that the increasing trend is not limited to beer, as the average per adult consumption of other alcoholic drinks has also significantly increased, taxes on alcoholic beverages other than the beer should also be raised. The proposed rates for 2024-2025 entail approximately 7% increase in all alcoholic beverages compared to the current rates. In line with WHO recommendations, the proposed tax increases slightly exceed the current inflation rate to effectively cap the affordability of these products while simultaneously increasing revenues. It is recommended that the tax rates for all alcoholic beverages be substantially raised above inflation. The proposed modest increase is unlikely to reverse the concerning trend of increasing alcohol consumption in South Africa. More significantly, tax increases would yield better health and revenue benefits. WHO therefore recommends a tax increase of more than 10% for all alcoholic beverages. On the drivers of illicit trade, there is evidence, and it shows that weakened tax administration has a significant role in driving illicit trade in tobacco and alcohol products. Experience from many other countries demonstrates that illicit trade can be successfully addressed even when taxes and prices on these products are raised. The protocol to eliminate illicit trade in tobacco products is an international treaty that aims to combat the illicit tobacco trade through various measures, including supply chain, e.g. tracking and tracing, offense prosecution, and international cooperation. South Africa should become a party to the protocol and partner with the international community of countries committing to addressing illicit trade in tobacco products. At the same time, it should work on implementing the protocol provisions to improve tobacco excise tax enforcement and administration. Tax evasion in all products, including electronic cigarettes, should be addressed. Similarly, strengthening tax administration along the supply chain of alcoholic beverages can reduce unrecorded alcohol consumption independently of the increase in taxes and prices. Chair, we thank you for this opportunity that has been made to us to make this presentation, and to the standing committee. Thank you.
Thanks very much, WHO, and also for keeping to the time that was allocated to you. Thanks very much. The next stakeholder is the South African Institute of Chartered Accountants, SAICA. Over to you, 10 minutes.
Yes, thank you, Chair, and the committee members for this opportunity. My name is Lesedisa Foro from the South African Institute of Chartered Accountants. Let me just load my presentation quickly. Okay. Share. So here's just a table of contents of some of the items we will be covering. We will be looking at public consultation, as well as broader tax policy matters, some of the proposals that we are in favor of and we welcome wholeheartedly, and others where we do have concerns and we will be addressing. Beginning with the public consultation process, we were happy to go through the legacy report from the 6th Parliament, which we know that this committee had a presentation on by Mr. Hlophe. We were very encouraged and we agree with some of the recommendations as shown in this slide, particularly concerning the induction training on the tax law, as well and how it should be facilitated by National Treasury and SARS, which we know was done about 3 weeks ago. We are also in favor of the recommendation that the induction should have an element where other experts outside of government can be given the opportunity to assist in the induction. And what is also very promising to us is the recommendation concerning the consultation process and how it should not just be limited to the budgetary cycle, but should be an ongoing event. Some of the concerns we have are that there is currently no ongoing forum where the private sector and the public sector can engage, can meet regularly to discuss some of the longer term tax policy matters. As a recommendation, therefore, we are of the view that there should be such a platform happening throughout the year, not just concerning these bills, but also throughout the year. Again, with regards to the public consultation, with regards to the induction, we would like an opportunity to have some input into that so that we may also be able to facilitate this committee consulting with other tax experts who are outside of government, and SAICA remains available to assist in those arrangements. With regards to the public consultation process, this is just, although it's rather small, this is just an example of how it currently happens. Currently, between the time when the budget is presented to the minister, when the minister presents the budget, and July, when the draft tax bills are published, there is no consultation between industry and government to go through the proposals as per in the budget. So we would like to see some sort of consultation that's happening there. The other concern that we have is that between the deadline for the submissions on the draft tax bills that we have to make and the time of this particular hearing, we do have the workshop between those two time frames where Treasury and SARS in principle agree to some of the recommendations, although sometimes they don't agree to others. But we would like to see that the version of the bill that's being considered in these current hearings should at least have some sort of, should at least be updated for what was discussed during the workshops, giving SCOF a more rounded view of what industry was saying in response to the draft. In 2017, we made a presentation to this committee under the previous parliaments, where we showed, with regards to the public consultation, some of the challenges being experienced, some of the impediments with regards to the participation. We saw that this is coming from the PMG survey, listing things like lack of time, insufficient knowledge of the tax policy, as impediments to participation from various stakeholders. At the bottom left there, we can see also with regards to commentators feeling that 80% of the issues that they raised were not necessary, they received no feedback on. And we do see that 30% felt that their submissions were considered, whereas the 37% felt that they were not taken seriously. That's just an idea of what we are hoping that the public consultation can end up being. In an ideal world. We would like, again, as I said earlier, for between the time of the budget and the time the draft tax bills are published, there should be some public consultation between National Treasury and industry with regards to discussing what will eventually be in the draft tax bills, as well as some of the issues that we can expect to see. Currently, there is nothing, there's no consultation in that regard. So we are asking, and we do know that this committee has considered such things, particularly concerning the fact that there's not enough time for you to consider these bills. So we are asking that those timelines continue to be reviewed with a view towards improving the consultation process. With regards to the proposals, those are just some of the issues that we support wholeheartedly, concerning, for instance, the employment tax incentive and how there's currently abuse, which SAICA has raised in previous years. So we are happy to see that Treasury has amended that particular legislation with a view to improving and curbing that abuse. We are also in favor of the new investment allowance with regards to the electric and hydro-powered vehicles, and we are happy that it is part of addressing the climate change challenges that the country is having. Some of the issues where we do have concern particularly the input VAT claims and the proposed amendments there too. We would like to set out at the start that this particular proposal was completely opposed by small as well as large businesses. Currently, the situation with input VAT claims concerns the fact that taxpayers have 5 years within which to claim the input VAT. The proposed amendment, however, does seem to limit the amount of time in which the input VAT can be claimed. It must only be claimed during the month when they receive that supplier invoice. The obligation to claim is limited to that and not the entire 5 years. Why the change? National Treasury has said that they are finding that a lot of VAT vendors are claiming after the current 5-year limit, which is illegal, as well as they are finding that there's double deduction of input VAT, which is very problematic for the fiscus. Some of the concerns we have about that is there are reasons why taxpayers do not claim all the input VAT upfront. There are issues, for instance, with VAT refunds. A lot of vendors do not want for there to be, they don't want to receive refunds because they know that they will be subject to audits and it will take us a long time to have those to pay out the VAT refunds. Those are just some of the practical issues that have to do with why, if this amendment were to go through, these are some of the practical issues that will be caused should the proposed amendment go through. What we are recommending is that the proposal be withdrawn, that there be further public consultation, as well as SARS giving us giving us data to clarify the circumstances in which they are saying that the concerns that they have justify this proposed amendment. The second proposed amendment has to do with the assessed losses for companies that are closing down, liquidated or deregistered. Currently, we know that there's a limitation on the amount of prior losses incurred by such companies. They are limited to R1 million or 80% of taxable income. The proposed amendment does away with that limitation where a company is closing down. The concerns we have about the fact that it takes more than 1 year to shut down, in which case in the subsequent years, the company is not able to even access setting off that assessed loss. So we are proposing that the trade requirement for all years when companies are in liquidation, that should be done away with to allow taxpayers to fully claim that those losses. We also have a proposed amendment this year on the foreign exchange losses that are incurred. Our initial request was for the forex losses to be allowed to be deducted whether or not a taxpayer is trading. Currently, gains are taxed, but losses cannot be deducted unless a taxpayer is trading. However, the proposed amendment the proposed amendment allows for the forex loss to completely not be deducted in the year, to only be carried forward to future years. And our recommendation is really that we revert back to our initial request. Our last issue that we're looking at concerns the global minimum tax bill. Currently, it's effective January 2024. We are against that because of the fact that the law has not yet been finalized. However, the tax is still companies are still subject to the tax despite the law being finalized, and we do not feel that it is fair. 1 January 2025 is an appropriate effective date. Matters not in the bill, those are just some of the issues we've listed in our submission, and we encourage the committee to have a look at those. Thank you, Chair, to the committee for the opportunity, and I'll leave it to the next presenters and commenters. Thank you, Chair.
Thank you, Saika. The next stakeholder, South African Institute of Taxation.
I can't hear. Okay. Am I on? Is everybody listening? I can't hear. Can you hear for a second?
We can hear you and can see your presentation. Please proceed.
Good day. How are you?
Fine.
Hello?
Yourself.
Oh, great.
Yes,
Thanks.
sir.
Here's Mr. Engel. Please hold for him.
Hello, everyone. Sorry, I just having a little trouble with my systems. Okay. Let me follow on the presentation of Saika. Let me just say that I fully agree with what Saika is saying. So we're not going to repeat everything the same there, but I think that was an excellent presentation. Thank you, Lissetti. In terms of the VAT, I do think this is a very sensitive issue. So SARS is trying to limit the time claim in which you can claim inputs. And I think for the reasons that Saika said, we need to be very, very careful here. That this amendment looks innocuous, but small businesses especially are having problems on refunds. This is going to make it much more difficult. Everything's going to be subject to challenge. And I understand that SARS has an abuse concern, but they need to actually tailor the anti-avoidance without affecting matters generally. The refund issue on VAT does remain a problem. Things have improved considerably, but we still have issues here. So, but I think Saika stated this case fully, so I'm not going to carry on this one. What's the next slide? Let's see here. There we go. Perfect. Okay. The 24I amendment, also, I'm going to agree with Saika on that, is that I'm not really sure when you look at the amendment what the purpose was, but I think people have to understand that currency losses and currency overall is something that the taxpayer mostly cannot control. You're not sure of when your currency value is going to go up and down. There really is very little power over that. And for a lot of our export and import businesses, it remains a very highly risky affair. And so if you're going to start limiting losses, what you're going to find is if a taxpayer has several years of losses, and it's going to have a real economic effect on them, you're basically saying they can't get the tax losses until much later. And I think that's unfair. If government wants the currency gains, they have to accept the currency losses. If there's an abuse, and it's sort of alluded to in the discussion, is that I think they're worried about speculative trading in currency. Now, if there are concerns about speculative trading in currency outside of a trading context, I think they need to make that more clear. And so this amendment needs to be refined in both its purpose and in its legislative language. Next one. Okay, so the issue that was not mentioned by Saika is trusts. Now, when people have offshore trusts, the basic funding mechanism is a loan process. So most people fund their trusts by having the trust borrow the money and a loan. And we've seen a lot of crackdown on 7C. And what 7C says domestically is if the trust borrows the money, they have an imputed rate of interest. Now, once you cross border, the right answer is Section 31, i.e. transfer pricing should apply. So whenever you have a loan or any other transaction that's cross-border, what must happen is transfer pricing prevails to make sure things are done according to international fair market values. Now, the current 7C legislation is actually written in a way where it's not clear how things work. And I think right now, if you read the legislation aligned with SAR's interpretation, cross-border loans are falling under 7C, a deemed domestic interest rate, as opposed to the cross-border loan rate. Now, the amendment is trying to introduce the following, that if you have a cross-border loan, that you'll get the higher of domestic interest charge or the transfer pricing charge. And we think that's fundamentally wrong from a treaty point of view, an international paradigm point of view. Whenever you have a market value problem or low interest problem, treaties will say Section 31 prevails, i.e. transfer pricing. And if you're going to pose a higher of test, what you're going to introduce is an element of double taxation, where the other country is going to be imposing transfer pricing and we're going to be going higher of. And so we think the international standard should prevail on cross-border loans, and there's no difference of a cross-border loan with a trust or any other transaction. Next one. Public officers. We welcome the amendment. I think there might need to be some procedural clarifications, but when you set up a company, every company needs to have a public officer. Now, that public officer is the central communication point for SARS with the company. So we think that's correct, and there's no problem with that. But under current law, what they're trying to do, and they've had it for some time, is they're trying to make the public officer secondarily liable for the entire company's debts, tax debts. Even if it's a public company, even if the public officer has no stake in the operation whatsoever. And that means somebody who is innocent can be found guilty of something they haven't done, even if they've made an error. And so one of the things that's very important as public officer is, one, making sure that people who are appointed understand that appointment, and it's got to be done quickly. And two, they've got to be able to get off fairly quickly. So I think the amendment helps to some extent. I think we need to be clear on the list a little bit to make sure it makes sense and that somebody is not being caught unaware. But also, we need to make sure that if somebody wants off the list and they can't get off because SARS systems or things outside their control, they can't be held liable. But overall, we support this amendment. We just think it needs a few clarifications on some related matters. Next one. Big issue here is going to the tax court. We realize that we're responding to a recent court case, that we don't just need the lawyers in tax court, we can use others. So we approve the process in which fit and proper is being expanded. I think what we're just asking for is a bit more clarity. We think that one requirement is that you should be fit and proper, but you should also be a tax practitioner if you're going to be representing others. So I think we just want a little bit more clarity. I think the amendment is vague. Maybe that clarity can be obtained through SARS guidance in quick succession. Next one. Okay, ADR. Now, when you are in dispute with SARS, they first will file a verification letter, then they will issue an audit, then you will complain, and then what happens is you then can object. If they don't like the objection, then you can appeal, and under current law, you then can go to ADR and for an alternative dispute procedure. Now, the ADR process is about having an independent person give you a recommendation how to settle this quickly and amicably from an independent point of view. And we support the amendment that you move the ADR process up sooner to avoid all the excessive appeals. However, I would say that the ADR process needs some improvement, that we need more independent adjudicators. It doesn't help to just have the same SARS people who are dealing with the objection and appeal being the ones who are in ADR. After all, ADR is non-binding. So we would think that would be the better improvement. Otherwise, the process really just becomes another ground of appeal and delay. But we support the amendment overall, and we just make the request for independence. Next one. Unlisted REITs. Now, this is a funny one. Right now, the real estate investment industry that's listed receives certain tax relief to prevent double taxation. So real estate investment trusts and there are about quite a few of them that are out in the market, are quite large, and you invest in them and they invest in malls and warehouses and basically apartment complexes and offices. And all of those get a special relief mechanism in order to facilitate investment. And that relief is the same as collective investment schemes. This change was made about 12, 13 years ago, either in 2012 or 2013. The problem is we've given relief to the listed industry, but not the unlisted industry. Now, government wants to give this relief, but they keep making it dependent on the coffee bill by the FSCA. And while I think that method is a reasonable option, we're finding that the coffee bill just gets delayed year after year after year, and the unlisted REITs are being left out in the cold. So we do appreciate the amendment that is done that's indicating that they are definitely intent on doing this and that there is going to be some transitional relief. But we think that transitional relief needs to be expanded temporarily because the coffee bill and the actual final relief is a long way away. So we would just request some small changes to give the industry relief until the final transition happens. Next one. Okay, fueling confusion. Now, it came up in the papers, there was a mistake in the tariff structure dealing with light fuels. And we planned to put it under the WCO standards, and there was an error that dates back to 2002 that we need to correct. And I understand that does need to be corrected. Now, the problem, though, is that the clarification goes back to 2002. And to the extent that people relied on the law, I think to go back retroactively and change it is I think that's a constitutional violation. So we understand, however, we don't want people to file requests for refunds based on an error so long ago. We would recommend that the legislative amendment goes back to 2002 to make sure people cannot get refunds, but that some sort of legislative amendment is made that those people who relied on the prior classification, who have basically paid their due, that the SARS can't audit. So basically, if you want to go back before 2012, the answer is no refund, no penalty. And then if that's what they want to do, that's fine. But to go back and penalize people going back, that is a problem. And I think that's grossly unfair as a constitutional matter. ETI. Now, this is the employment tax incentive.
Hello.
Yeah. Yes.
You are allocated 10 minutes. You have gone beyond that.
Oh, sorry. Then let me just do one slide.
You concluding?
I'm almost done. Sorry about that. I'm not able to see the time. I'm going to give you one slide. Skip over this one. Psych has dealt with it. This is the last one. There is in the world of VAT, there's a big issue around electronic services. And one of the issues has been that we want to make sure that if you are a foreigner and you do electronic services in South Africa, that you are subject to the VAT. And there's been a lot of issues around that. And the new exclusion for B2B is very supported. We think that if you are a parent company supplying services to a subsidiary in South Africa, we think that needs to be outside the registration process. The problem is the amendment is giving an exemption far too broad because it can't be tracked. So we would suggest, even though it's a favorable amendment, that we narrow this slightly so it's easier for reporting purposes and we focus mainly on connected persons and group players. Sorry for going over time, and we wish the committee well.
Thank you, Keith and your colleagues. The next stakeholder, Old Mutual. Over to you.
Good morning. My apologies. This is Nazreen Carver representing Old Mutual Limited. I've lost my voice, so I'm going to ask Faisal Khan to please step in for me. Faisal.
So I'm just trying to share my screen. Can you see my screen?
We can. Could you put it on slideshow, please, Faisal? Okay, go ahead.
Okay. We'd like to thank the committee for giving us the opportunity to present to the committee. So the first point, we'd like to reiterate what SITE has just said about the unlisted REITs issue, in that the provisions of 23M are creating certain unfair tax implications for the unlisted REITs compared to listed REITs. Now, we had done a presentation.
Sorry, could we ask you to give us the next slide, please? Could we have our next slide, please?
Sorry, it's not seem to be moving across.
Hazel, just go ahead.
Problem with the slideshow here. Let me just end the slideshow and try.
There you go. Thank you. Just carry on like this. Thank you. In the interest of time.
Yeah. So whilst we had done a presentation to SCOF regarding this issue and the impact that it does have on pension funds that invest via life insurance companies, and the double taxation that occurs. So we happy with the amendment that SARS has proposed, but the problem with the amendment is that it requires the FSCA to provide regulations, and there's no timeline for the regulations of when this thing would be implemented. And as a side said, this thing has been coming for the last 10 years.
Faisal, could we have your next slide, please? It's the one that explains the issue. You're on your contents page. Thank you.
So effectively, the amendment that the National Treasury has proposed is not effective because there's no deadline imposed for the FSCA to publish these required regulations. As such, we think that certain interim measures need to be put in place until the FSCA publishes the regulations, because we are unsure what the timelines are going to be. And as you said, this is quite a long outstanding issue. In addition, the implementation rules do not expressly provide for where tax-exempt investors are invested in infrastructure funds, like renewable energy, development impact funds, and social impact funds. This also needs to be included in the 23M exemptions going forward. Because effectively what this does is it makes the pension funds paying tax twice, once in the investee company and then the second time when the pension receives its pension payout. The second issue we'd like to touch on is the definition of a trust. And what National Treasury has done is they've included the definition of a collective investment scheme. So they've defined a collective investment scheme to be a trust. Now, in dealing with a trust, there are a number of sections that are specifically impacts trusts as you go throughout the legislation. And these other sections have not been amended to specifically cater for collective investment schemes. So either, we need to go back and amend all of the other sections because they will have unintended impacts on collective investment schemes, or we remove the definition of collective investment schemes from the definition of trusts and bring in a separate tax rate section for the collective investment schemes themselves. Because the intention of bringing it into the trust definition was so that a tax rate can apply to the collective investment schemes. So the easier way of actually achieving this aim is to simply bring in a tax rate for the collective investment schemes rather than including the definition of trusts. Lastly, we'd just like to touch on the global minimum tax. which essentially impose a 15% minimum tax on multinational enterprises. However, South Africa has got a life tax regime where we've got the 5 funds and certain tax-exempt investors, for example, pension funds, invest into the untaxed policyholder fund of the life company. And the intention is, that the income flows through this untaxed policyholder fund and ends up in the pension fund tax-free in terms of South African legislation. Now, with the implementation of the global minimum tax, we are ending up with a global minimum tax at 15% on these investments that this untaxed policyholder fund makes. And so unfairly now we're getting this double taxation once again flowing through to the pension funds. So we're asking National Treasury to consider additional legislation to shield this additional tax flowing through the life companies. Thank you.
Thank you very much. I think that is all from Old Mutual.
Okay. Thanks, Old Mutual. The next stakeholder, Asisa. Over to you.
Sorry, Chair. My hand is up. I don't know if you can see my hand. Person?
I can hear you. I was struggling to unmute you. Honorable Van Rooyen.
Okay, Chairperson, Asisa made the presentation yesterday, so they are having another opportunity today. I'm not sure if does this not opening the committee to accusation of biasness?
They are allowed because remember, it's a continuation of what we did yesterday. The bills are not exactly the same. So in terms of the rules, they are allowed to can come again and make a presentation.
All right, thank you very much for the clarity.
There are specific issues which were not dealt with yesterday, which are dealt with today in these bills. So somewhere, somehow, the contents of the bills are different and the issues that they are addressing.
Okay, thank you, Chair. I hope that's clear to all stakeholders or those who are making submissions. Thank you very much.
Yes. Thanks, Honorable Van Rooyen.
Good morning. Yes, my name is James Coutinho. I will be representing Asisa on this presentation. I do want to state that we are not doing the same presentation as we did yesterday. The presentation yesterday related to two-pot, and today's presentation is limited to the global minimum tax provisions. So if you may, if I may, we are specifically going to talk to two-pot. Who is Asisa? It's important to note that Asisa represents retirement fund administrators, investment managers, long-term or life insurers, and collective investment schemes. Our concern is that the global minimum tax affects long-term insurers that are part of multinational enterprises. As has been mentioned by Old Mutual, global minimum tax is a tax on multinationals and in principle is not meant to tax policyholders or retirement funds or pensioners, annuitants, or exempt institutions. The OECD guidelines, however, do provide specific relief for insurance companies with respect to the investments that they hold, but only if certain very specific conditions are met. we've reviewed the OECD guidelines, and due to South Africa's life insurance company's unique structure, which is the 5 funds system of taxation, we are of the view that the current OECD guidelines do not suffice, and consequently our South African life company structure do not fulfill the conditions for relief that we expect in respect of the local and foreign investments that they hold. And consequently, and unintentionally, the investments that South African life insurers hold will be unduly subjected to global minimum tax. Now, without appropriate changes to either the OECD rules and guidelines or specific local legislation, in other words, specific intervention in the local provisions, the current global minimum tax provisions will add an unintended level of tax up to 15% to policyholders. And the most dire impact of this will be for those policyholders which are either retirement funds or which are pensioners or annuitants sitting in the untaxed policyholder fund. Now, we would like to place on record that we wish to thank National Treasury and SARS for availing themselves to actually fully understand our issues and for specifically taking our concerns to the OECD and for arranging a recent meeting with OAC representatives and the industry so that the necessary relief can be explored and provided. Our understanding is the OECD is considering the way forward to provide the necessary relief to while working with National Treasury and SARS. And we would like to state that we will look forward to continued engagements with National Treasury, SARS, and through them the OECD to ensure that the necessary and appropriate relief is given to our policyholders and the policyholder funds that we run. Thank you. That's the presentation.
Okay, thanks, Asisa. The next stakeholder, PwC.
Thank you, Chair. Just give me a moment to share my presentation. Okay, thank you, Chair. So, by way of introduction, my name is Carl Mandy. I'm tax policy leader for PwC. I'm just going to go through a few of the highlights in terms of the submissions that we have made to SCOF in relation to the proposed amendments in the tax bills. I'm going to try not to, in the interest of time, try not to repeat what has been said by others. So let's get into it. Just the first item I do want to highlight is in relation to the proposed incentive for production of new energy vehicles, and the incentive for that. While we certainly welcome the incentives being proposed, the aspect that we want to highlight, and we have raised with Treasury as well, is that the Pillar 2 rules, which Asisa have just been talking about, will potentially, to some extent at least anyway, undermine that incentive. And that is because that incentive could have the effect that it reduces the effective tax rate of the OEMs in South Africa, or certain of the OEMs in South Africa, to below the global minimum tax rate of 15%. And that could result in effect, parts of those incentives being clawed back through the application of the global minimum tax rules. What we've suggested is to Treasury that they do is to revisit that, to have a look at that, to consider it, and possibly consider other ways in which that incentive could be provided without it being potentially undermined by these global minimum tax rules. The second aspect that I want to get into, and there are two elements to this, is around the proposed changes that are being made to the tax treatment of exchange differences. The first element of that, there is a proposed amendment to introduce essentially as an item that is subject to exchange differences any shares that are effectively classified as financial assets for accounting purposes. We understand that what Treasury is really after is certain preference shares that have debt-like features. But unfortunately, the way in which that amendment is crafted is it goes much wider than that, and for example, brings into the equation such shareholdings as investments in subsidiaries or essentially any and all investments in shares, and starts treating those as exchange items for purposes of the taxation. We've suggested that be narrowed. I think Treasury has acknowledged that the amendments are far broader than what was intended, but we look forward to that being narrowed and appropriately targeted to the issue at hand. So I think it's important that the committee is aware of that because it has potentially far-reaching consequences. The second element that, insofar as exchange differences, that I want to touch on, and SART has already spoken about this, but maybe just to give some more insights in relation to what is at hand here. The problem that Treasury is trying to resolve is an age-old problem that has been there for many years, and that relates to companies that are not carrying on a trade. Many years ago, the section in question was amended to bring within its scope exchange differences associated with non-trading companies. And that has had a number of unintended consequences, most importantly of which is that exchange losses that are incurred by those companies are not able to be carried forward because of the assessed loss rules that do not allow assessed losses to be carried forward for non-trading companies, and set off against exchange differences that may arise on exactly the same exchange items in subsequent years, given obviously the volatility in currency movements. And that is obviously inequitable. It goes without saying that non-trading companies could essentially end up being taxed on what amounts to no actual exchange gains on a net basis over the course of a number of years, and even worse, being taxed only on gains with no corresponding set-off of losses at all. What Treasury has proposed to do essentially results in all companies not being entitled to net forex, to be able to deduct net forex losses. So that what they've done or proposed to do is it goes a whole lot further than addressing the issue that they should actually be addressing. Treasury has acknowledged that they have actually set up a consultation for Friday this week, and again we look forward to having a robust discussion with Treasury and hopefully resolving that issue. But again, I think it's important that the committee is aware that there are significant problems with that proposal. The next issue that I want to deal with is in relation to the connected person definition insofar as it applies to partnerships. Now, Treasury has proposed an amendment to soften that definition in some respects, but we would submit it doesn't go anywhere near as far as it should. The problem is that even in relation to limited liability partnerships, it doesn't fully address the issue at hand, in that it doesn't remove partners in relation to those partnerships from being connected persons in relation to each other. And we would submit the entire definition insofar as it deals with partnerships, not only limited liability partnerships, but also unlimited liability partnerships, if you like, is completely nonsensical. It essentially makes all partners of partnerships connected persons in relation to each other. And in fact, the knock-on implications of that go a whole lot further, with many, many unintended consequences. For us, it's difficult to see what the policy rationale is for making members of partnerships connected persons in relation to each other in the first instance. We don't have shareholders of companies being, by that reason alone, being connected persons in relation to each other. So what logic there is for making members of partnerships connected persons is beyond comprehension. That's been an age-old position. It's been in there for certainly at the very least since 1962, when the Current Income Tax Act was introduced. But it is something that needs to be relooked at and should be relooked at and reconsidered as to what the logic of that is. One more aspect that I want to deal with in the context of Income Tax Act is the definition of a trust. This has been touched on by others, but so I don't want to get into this, but insofar as collective investment schemes are concerned, there are potential significant implications with including CISs in that definition of a trust. And we would encourage that this be carefully considered and relooked at, and those consequences carefully considered before any changes are made in this regard. The final issue, insofar as the amendments are concerned themselves, that I want to touch on is in relation to the input tax claims for VAT. Both SITE and SACA have spoken about this at length, so I'm not going to repeat what they've already said. Safe to say that we fully support the comments made by them, and we do believe that this is something that needs to be very carefully considered and not simply just introduced without actually understanding what the consequences of that are and the knock-on implications for taxpayers are. The last matter that I want to raise is in relation to various consultations that need to take place on a number of different issues. I'm not going to cover them all off, but there are many, many outstanding issues that need to be consulted on, discussed, and workshopped with Treasury, and which Treasury has undertaken to hold further engagements on. To date, there have been no indication of those consultations actually taking place. Nothing has been scheduled in relation to those, and we would strongly recommend that these are workshopped and consulted on as a matter of urgency. Many of these issues have been outstanding for a considerable period of time, and it is important that those are addressed in a timeliest manner. No, thanks, Chair. Let me leave it at that. Thank you.
Thanks, PwC, for the presentation. The next and the last stakeholder is Sapua.
Can you see my slides?
Yes.
I just want to share it. Thank you very much, Chair and the committee members. My name is Smithel Rambai. I'm the chairman of the South African Property Owners Association, the Unlisted REIT Committee, and I'm here to present on the prejudicial impact of Section 23M on retirement funds invested in property. So I just want to firstly say that I want to thank National Treasury for acknowledging the Section 23M issue. Treasury, in the 2024 budget review document on the 21st of February, on page 44, published that the interest limitation rules, which pertain to Section 23M, the current law limits interest deductions where there's a relationship between the debtor and the creditor, and the corresponding interest income is not taxed fully. An unintended consequence of this rule may unfairly prejudice tax-exempt investors such as pension funds. So I want to just leave it at that there was an acknowledgement that pension funds or tax-exempt investors with certain provisions in 23M would be unfairly taxed. We asked for two required solutions. One was an interim stopgap measure to protect all tax-exempt investors, such as pension funds investing into unlisted real estate investment trust funds, until the longer solution was put in place. And then we obviously asked for that longer-term solution, which extends the REIT legislation to include unlisted REIT funds. We again want to thank National Treasury for proposing a longer-term solution. Basically, what National Treasury proposed was that the REIT definition in Section 1 of the Act be extended to cater for a company that is a South African company that is not listed on the South African Stock Exchange, but is regulated by the FSCA through the published requirements approved in consultation with the Director General of National Treasury. However, there are issues with the proposal. There are shortcomings on a few fronts. There is no effective date, and there is no deadline by which the FSCA is required to publish the approved regulations, which renders the legislation ineffective until the FSCA publishes the relevant regulatory framework. I think what I'd like to also add is that the current stopgap measures that are in place around Section 23M does not adequately protect all the tax-exempt investors, such as pension funds and untaxed policyholder funds of insurance companies that have issued direct and indirect debt until the FSCA publishes that relevant regulatory framework. And I'll touch on why this will have a large negative consequence for the industry shortly. So we had proposed an interim solution to National Treasury, and it's not complicated. There is a wording in Section 23M 6, subsection 6B, where just subtle wording changes are required to create the effect where the unintended consequence that was acknowledged by National Treasury would be resolved. And I'm not going to go into the details of the wording that we suggested, but I've just provided it on the slide deck for reference purposes. But these are very subtle changes that need to be made to prevent the unintended consequence. And it will also create the same effect as National Treasury trying to actually tax those that are intended to be taxed. The negative consequences are the following. If no action is taken at all, the impact to tax-exempt entities such as pension funds will be catastrophic, as they'll pay 27% more in tax, effectively being double taxed, as pensioners will pay tax again when retiring. It will also prevent transformation in the property sector, as many new Black-owned property investment management businesses receive seed investment from institutions like the PIC to build a track record. They will not be able to compete and grow their businesses due to this impediment, as it will affect the performance of the property fund they manage to attract future capital investment from investors other than the PIC. So our recommendation is simple, that the Standing Committee on Finance consider the proposed interim stopgap measure wording in Section 23M 6B to protect tax-exempt entities such as pension funds against being unfairly taxed. We also ask that SCOF ensure that National Treasury and the FSCA commit to a deadline to implement the longer-term solution and provide a date for it to be effective. Thank you very much.
Thanks, Sapo. The next item is the engagement by members of the committee. Clarity seeking questions and or comments. And you will assist me. There's something not right with my screen this side. I see Honorable Bateman, Makuela, Beasley. Is it Van Ryan? Is it so?
Yes, sir, it is so.
Not the hands, it's Honorable Bateman.
Makubela, Beasley, and Van Rooyen. 4 hands.
Makuela, Beasley, Van Ryan. Okay.
Yes, sir.
I'll get the computer, the screen sorted. Over to you, Honorable Bateman.
Thank you, Chair. I would like first just to thank each one of the presenters for their high quality presentations. I thought each one engaged in a very constructive and helpful way, and that each of the different points that have been made, not only in these presentations that have been done live, but also in the fuller written submissions, do certainly warrant responses from National Treasury. And on this, I'd like to just echo the point that was made by Saika about asking National Treasury for a full response with feedback, and also showing how those responses find their way into the bill or don't find their way into the bill. I think what would be very sad and dishonoring towards those who've made contributions is if there's just a silence from Treasury in terms of the way in which the responses are formulated and provided to each of the presenters. Then just lastly, I'd just like to pick up one of the points that was raised, I think, in the Kasatu presentation. It might have been raised in one of the others as well, is the President made reference to reviewing the fuel levy and also expanding the basket of zero-rated foodstuffs. And these are both items that have been championed by the DA, and it would be obviously remiss not to include those in this upcoming budget. So just wanted to make those 3 points: the quality of the presentations, acknowledging that and thanking the presenters, asking that we can see full response from National Treasury, and how those responses find their way into the final bills, and then also the point about the fuel levy charges and the zero-rated foodstuffs. Thank you, Chair.
Thanks, Honorable Bateman. Honorable Makuel.
Thank you, Chairperson, and greetings to yourself and my fellow honorable members and all on the platform. Chair, my question is to the World Health Organization. They propose, Chair, on the health promotion levy that the tax for sugar drinks should be above inflation, so that it then encourages, or it makes it unaffordable for consumers to consume sugar drinks in a way to promote healthy living. And that, Chair, should be what then says at the end of it all, a nation should become healthy, the burden of diseases should be reduced, and citizens are healthier. But then I want to then understand, Chair, if World Health Organization has empirical evidence that this does translate to actual meaningful changes to lifestyle. And then what are then the gains of such taxes to ensuring that a nation becomes healthy, or it becomes just one of those taxes that increases the tax burden on consumers, but there are no empirical evidence in relation to the objectives aimed at reducing consumption and ensuring that a nation is healthy. And then the second question, Chair, goes to COSATU. COSATU suggests a chairperson that makes the presentation that make a submission that in ensuring withdrawals do not push low and middle income workers into a higher tax bracket, government must not tax the withdrawals. I just want to understand, perhaps maybe an explanation of how best do you think, or does COSATU think a government can tax on the withdrawals? Or perhaps maybe if I would understand if COSATU was suggesting the percentage of the taxes to these withdrawals, and also perhaps in the age cap for the withdrawals. Thank you, Chairperson.
Thanks, Honorable Mukwala. Honorable Bisley.
Thanks, Chair. And yeah, I just agree with Honorable Bateman. I think the presentations were exceptional, and I think it's imperative on our committee that they are answered to and that they are heard. So I've just got two questions. The first one is for COSATU. Have they got a proposal what goods should be further VAT exempted and fuel levy? I think it's important if we're asking for these things that we do a proper costing. So have they got a proposal and what it would actually cost the fiscus? And I think Honorable Bateman said it's a DA initiative. I think all parties agree that the VAT basket should be extended and fuel levies should be reduced. So I think it would be important if COSATU is making the proposal, if they've listed the ideas and if they've actually costed it, to actually see what it would cost the fiscus. And then in terms of the World Health Organization, they acknowledge that increasing excise taxes is driving illicit trade. Should one of their recommendations not be that the tax administration is further strengthened and capacitated to tackle that illicit trade, to make sure that when we're not putting so much excise tax on legitimate businesses, that we are preventing the legal trade? Thank you, Chair.
Thanks, Honorable Bisley. Honorable Van Rooyen.
Yeah, hello, Chairperson, and also a word of gratitude to all presenters with the information shared with us as members of this committee, and a very good morning to all of us, to all who are in participation now. Shall we start with COSATU? The first question will be on their assertion on NETLAC. It seems as if NETLAC is being not respected by National Treasury, or maybe the engagement, as they correctly concluded, the National Treasury is not engaging in good faith with stakeholders that are participating in NETLAC. Understanding the role of NETLAC, that's a very serious platform, and I think that's a very serious statement to come from a key role player like COSATU. And I think as a committee, we should be better maybe armed, to make sense of this particular statement. So if COSATU can give more information on what is it that they mean by National Treasury not engaging in good faith, and also if there are any suggestions, specific suggestions, to deal with this particular problem, because it can be correct for a stakeholder like COSATU to come to this platform and make such a serious submission without maybe giving more information to the committee, so as the committee can find a way of addressing this particular problem. Does it mean NATLAC is just a compliance platform which is not respected by National Treasury? Can COSATU give more information on that statement? Secondly, to COSATU, National Treasury was here to was in the committee to outline this issue of taxation of the two-pot, among other things, the two-pot payments, pension payments. They made it very clear that the target of this system, or the target of the scheme from the beginning, was for those taxpayers who are below the tax threshold, So now, COSATU, according to COSATU, it seems as if this is not the case. I think we need to get more information. What does COSATU mean? Because National Treasury said there's no way in which those who are below the threshold will be taxed for being paid out of this particular scheme. Because from the beginning, the scheme was conceived to obviously ensure that disposable income is increased for those low-income earners and who are not above the taxable threshold. So it sounds bit, maybe COSATU can, notwithstanding their categorization, maybe they can give more information as to what does this mean, because National Treasury says this is not the case. All the people who get this particular 30,000, they are not, the money is not taxed because they fall below the what do you call it, the taxable bracket. So maybe COSATU can give some more information on that. Or maybe, and also COSATU can also give some examples, because when you look at the current composition of the exempted items, when you look into that basket, there are items that are stated there. Maybe COSATU could just give an indication of which items are they clearly recommending to be added into the basket. And then moving to World Health Organization, there is a school of thought that suggests that besides administration of tax issues that deals with illicit trading, most of our people, South Africans, get tempted to buy these illicit items because of affordability. Now, this school of thought is further arguing that this is mainly spurred by poverty, unemployment, and inequalities that are highly prevalent. And as we are all aware, they are on the extreme, the South African context, So I'm not sure what is what is this WHO take on that particular submission, because they seems not to be saying anything about the poverty levels, the unemployment rate, and inequality that is affecting the South African society as something that might be promoting the usage of illicit items. And well, this is not only said, and I think it came across from various presenters, the issue of how the unlisted real estate entities are being dealt with. I think on the appropriateness of the timeline to effect broader transitional relief, what I miss is there any specific deadline suggested by various presenters as a stopgap measure? Because I think they are suggesting that National Treasury must look at the provision of a deadline that will obviously ensure that this transition is smoothly managed. Is there any specific deadline that presenters can suggest to the committee. So as when we gauge National Treasury, their suggestions can be tested with National Treasury. Thank you, Chair.
Thanks, Honorable Van Rooyen. Honorable Mautwe.
Thank you very much, Chair. Let me also take this opportunity to welcome all the presentations that were done today and greetings to everybody on the visual platform. Chair, I'm going to start with COSATU because they were the first ones to present. You even called Matthew, Comrade Matthew. But Chair, the truth is that it's very difficult not to conceive COSATU's presentation in the context of everything else that's happening in the country currently. We learned from the media that there was a national day of strike that supposedly happened on Monday against the economic troubles faced in the nation. I'm still not clear what this means because they can't be the ones striking who were the first voice to support this so-called GNU of yours, comrades. And I don't know, despite what you are told, I was traveling freely here in Gauteng and I haven't had any matches of such, so it was not impactful. And really, I say this with full appreciation and respect to the workers who were told to join under unions under COSATU and vote for this formal liberation movement that has tended to be security guards of white monopoly capital. Chair, in the presentation that was made, you'll get the impression that COSATU has been reduced to nothing but a research desk for the National Treasury. Because firstly, Chair, COSATU proposed reform. For an example, on the two-pot system, it does not seem to solve the structural problem, but instead wants to put a bandage on a wound that is very deep and needs serious operation. I wish COSATU would really disabuse itself from this idea that it was intimately involved in the development of the two-pot system. Maybe what should categorize this is that they will just be made to feel like they're involved, just to tick a box, because if indeed they were, we would have addressed serious structural problems that we have in this country. As things stand now, Chair, for an example, the initial commitment was to review the whole VAT system that saw the VAT increase from 14% to 15% in order to go back to 14%. Because as you may remember, this 15% was introduced as a form of emergency. And that was way back then to address a very dire situation that we found ourselves as a country. But now the 15% is seemingly a permanent emergency, because since it was introduced, there's no voice that says, but you can't be in a permanent mode of emergency. When are we going back to the 14%? COSATU is very silent on it. It's not bothering National Treasury. Secondly, Chair, COSATU is talking about a basket of goods exempted, but there's no industrial action that was taken 5 months later after the president made that pronouncement. Why is COSATU not marching to Treasury to say, implement this a basket of goods? Because we know that our people are dying of hunger. The price of food has gone up tremendously. And things like 15%, things like basket of goods being exempted, those are the things that could, in the immediate, assist our people to just keep moving. Because right now, they're not even moving, they're standing still. Workers are drowning, and there's nothing that is going to change for as long as, Chairperson, 90% of the bank assets are controlled by the 5 big banks. That's FNB, Capitec, Absa, Nedbank, Standard Bank. And the indebtedness is not as a result of borrowing itself, but is due to the expansive nature of borrowing, made worse by the interest rate regime. Chair, we're hoping to hear from COSATU what they would want National Treasury to address, but it's not clear what the presentation is about. But on a more substantial submission, Chair, there's an issue we have not learned because of the first withdrawals of the two-pot system. We now know that, as advocated for seemingly by COSATU, as they're intimately involved, as they say, or as they claim, the government, through SARS and pension fund administrators, are the biggest beneficiaries of the two-pot system and not the workers. But also, Chair, it's not entirely true that it's actually the government that is the biggest beneficiary. Our submission is that the biggest beneficiary are asset managers. So it still puzzles us that COSATU speaks about government being the biggest beneficiary, but it's leaving the asset managers aside. Chair, the asset managers are the biggest beneficiary. COSATU must go and find out, do their own research on how much insurance companies are charging workers interest on the two-pot system, whether you are withdrawing or you are not withdrawing. They've increased the rates and they charge you whether you would withdraw or you do not withdraw. We were sitting there in Franschhoek. A presentation was made by Alexander Forbes to the Public Office Bearers Pension Fund Board that there has been an increase from April, but they came to ask for an additional increase that cuts across everybody, whether you're withdrawing or not. And when you withdraw, you even get charged more. And they presented big figures of the money that they made. Treasury was there. Colleagues from Treasury were there. And we are all shocked that actually the people who are making money out of this, it's not the workers, it's not government, it's actually the insurance companies. So COSATU must go and find out, why are these asset managers charging more on our people? And the third part, Chairperson, is that there is no regulatory body that regulates these increases. They just wake up in the morning and say, yeah, we build a system that now accommodates this tax implication. The system costed us 5 billion rand, an online system that costs that much. And then they take that money and put it across everybody. Go and do your own research and come back to this same committee to tell us what has been your findings. Secondly, Chair, I didn't hear anything about workers who went to withdraw money, only to learn that their employers were not contributing. Instead, the employers deduct the money from workers. They don't deposit it, but COSATU is keeping quiet. So the march on Monday should have been a march to fight for the workers who have been paying money, only to find out now that actually those monies has not been deposited into where they're supposed to do. So I would have thought that is why COSATU would take to the street to bring the country to a standstill, because this affects all our workers who are already in trouble because there's just no money. Now, moving to WHO, I'm quite happy with their presentation, because yesterday we were told that when you are depressed and all that, you drink alcohol and all. But WHO came clear to say alcohol causes societal ills without mixing their words. So what is more interesting is that they are clear on what needs to be increased from where to where. The excise tax on HTP, the electronic nicotine proposed tax, which that one, they did not give a specific figure, unlike the rest. They just say substantially and well above the tax increase. So it would be interesting to get to know what percentage are you suggesting, because on the cigarettes, you are clear, move from 4.7 to 8 to 10%, because we want less people being able to afford to buy these cigarettes, less people being able to afford this electronic nicotine, which ultimately leads to people then smoking. So you start with nicotine, then you end up being a smoker. Sugar beverages, we agree. The alcoholic beverages proposed, I don't think moving from 7% to 10% is substantial, Chair. I would really ask WHO to relook at this one, because if you look at all these other increases they are proposing, it almost like a double. But here you're only asking for 3% increase. And yet you say that alcohol has got brings about societal ills. So I think you should be aggressive enough to say from 7% to 14%, because we need less people drinking alcohol so that we can have a alcohol-free society. And that will be all for me for now, Chair. Thank you very much.
Thank you, Honorable Maute. So, Urina, Reba Machingalane, White Monopoly Capital. We fumalaga into you in a mode.
Ay, le bona man, Chair, le bona. Ah, we lo bitsa motho mo comrade. Ay.
Hi, wena. Okay, re tla go bona ka hosane, o tla re explainela ntho ya hao. Let me go back to the stakeholders. Tebo, please assist me with stakeholders who are raising hands to respond to the questions from honorable members. I don't see any on my side. I see, is it Comrade Matthew? Yeah. Comrade Matthew, over to you. And who's the next is WHO. Oh, Tebo, Butle? You have a chat network, Tebo. Comrade Matthew, over to you, and then WHO.
Okay, no, thanks, Chair. Thanks, honorable members, for the questions. I think we put the questions largely focus on practical issues, which is what we wanted to do. The bills are quite technical. We need to focus on the practical issues and what can be done, what can't be done, etc. So, Honorable Bateman, on the issue of the fuel tax regime, Chair, this has been an issue for some time. In 2018, Jeff Radebe, as Minister of Energy, made a commitment by 2019 the taxes will be reviewed, because about a third of our fuel price regime, through about 6 or so taxes and levies, goes towards taxes in essence. Last year in July, thereabouts, the Minister of Finance made a similar commitment. And of course, the President made it in the opening of Parliament address. The Fifth Parliament too made a commitment around the issue of VAT exempt goods to review the basket, etc. And we haven't seen really much progress. Also to Honorable Van Rooyen's question too, we've had discussion in NEDLAC for the past 2 years on this issue. And really what we've seen from colleagues from Treasury who come to these NEDLAC engagements, and even colleagues from business too, was a real dragging of feet and just simply refusing to engage in any substance. And we can show the committee in writing as well. We can also ask the DJ Murray Trust, a progressive NGO, because they've done quite a bit of extensive research on different items, basically what they call the 10 best buys, which could be exempt from VAT. Yes, it would be a cost to the fiscus, but an affordable one. But there'll be a benefit in terms of addressing the issue of child nutrition, growth of the child, ability of the child to pay attention in class, etc. And of course, the impact on their education, their career path, etc., etc. But some of the items, Chair, just quickly, is large eggs, it's speckled beans, it's pilchards, it's fortified maize, milk powder, soya mince, peanut butter, white rice or sweet potatoes, soup mix, and amasi. So those are kind of the 10 nutritional food items. We think, Chair, there also is an argument to make, for example, around sanitary pads for girls or women. Do you want to exempt them from VAT? Or could you look at an alternative of saying that they should be freely available in public institutions, schools, universities, clinics, etc., which could be easily accessible? We do think, Chair, that there's a need to revive the road accident fund and road accident benefit schemes bills as well, because about just under R3 a litre of the petrol price, fuel price goes towards the RAF. The RAF has got liabilities of about 400 billion rand. It is a mess. But a significant chunk of his money goes to road accident lawyers who profiteer out of it. It goes to wealthy individuals when it should really be earmarked for low-income persons like the UF and the compensation fund are. But those bills need to be revived and to be taken back to Parliament because they can set the RAF on a sustainable path and lessen its dependency on these expensive fuel tax regimes. And the good idea about the fuel tax regime review is that it puts money immediately into workers, to commuters, to businesses, to the economy, etc., to the pockets. Chair, just quickly on the health promotion levy. Look, we had a lot of discussions in the Fifth Parliament too around it. The health objective is correct, but we need to also bear in mind you have quite a lot of jobs. There's about 70,000 jobs roughly in the sugar industry, from the farms to the mills, the value chain, etc. There is a master plan, and part of the agreement was to have a transition because the industry also is battling with a flood of cheap imports, subsidized imports from Brazil, etc. And we also had a discussions, Chair, about 6 years ago, at NEDLAC, where the Department of Health had committed, and they haven't honored it, a mass public education campaign around a healthy lifestyles, healthy diets, etc. So that you don't just tax people, but also you empower them with knowledge about what they should eat, what they shouldn't eat, etc. Chair, on the issue of the tax regime for the two-part pension reforms, look, so the pension system obviously is geared upon tax incentives to reward you to save and tax disincentives to discourage you from withdrawing. But the whole point of the two-part reform is to give relief to workers who are drowning in debt, not because they're reckless, but because of the economy, rising cost of living, unemployment, etc., etc. Issues far beyond their control. You can't blame a worker for being in debt when Eskom has had double-digit tariff hikes since 2006. So the issue is to say, and we've, in our proposal, in our written submission, we have made about 5 options. Could you look at making, for low-income workers, those below the income tax threshold, and in the first 2 income tax brackets, other options, no taxation, for example, on early withdrawals for those below income tax threshold, that's basically clothing workers, etc., those below 96,000. Could you also make sure that, to Honorable Van Rooyen's question, avoid a person being pushed into the next tax bracket because they withdrew? So how that happens is, let's say, for example, you're a clothing worker, you make 90,000 Rand a year, you're below the income tax threshold. You withdraw 10,000 Rand, so now you're at 100,000 Rand a year, and the tax threshold is 96,000 Rand. So all of a sudden, you're now paying income tax, whereas before you didn't. So we think there is a need for some creative thoughts around that to give relief to workers. Previously under the tax regime, Chair, for withdrawals, is that the first 27,000 Rand was tax exempt, and then it was a flat 18%. Could you look at a first withdrawal being tax exempt, or could withdrawals below 30,000 Rand, for example, be tax exempt for low income workers? But we think there is a need to have some discussion to give relief to those. We did agree with Treasury about a progressive tax regime because you must make sure those who earn the least pay the least and those who earn the most pay the most. But we think there is a need for further discussions on it. Chair, I can easily ask NEDLAC if we can share the reports around the delays at NEDLAC by Treasury colleagues, but they have openly, with colleagues from business too, refused to engage in anything of substance around the VAT regime, the fuel price regime. And those are open documents. NEDLAC, openly shares those. Chair, just to Honorable Mautwe from the EFF, look, I think a lot of the Honorable members' comments were just political comments, and perhaps it's a reflection of the EFF's frustrations at being displaced to the 4th largest party, losing the deputy president, etc. We do hope the EFF will improve the performance attendance in this committee because the previous EFF rep was noticeable by his absence. A lot of the issues Honorable Mautwe has raised correctly, we have raised them in our October 7th, the strike which took place on Monday on the list of demands. All of those issues and plus many, many more have been raised there. So the EFF is supporting them, that's fantastic. We don't want to enter the GNU politics, Chair. I think for us, we have a government, irrespective of who's in office, whether you're from the PAC, whether you're from FF+, a minister must deliver and we'll hold them all accountable, just like we'd always hold our commerce from the ANC accountable. And just like when the EFF and the DA operate in municipalities, we do the same principles. But we had the day of action, Chair, to put a spotlight into workers' issues. So there's not an issue of having a quorum for a march. Whether it's one person, whether it's a million people, is neither here nor there. The point is to have a spotlight on the issues, and that's exactly what is done. I don't want to really respond to chairs to COSATU being a research desk at Treasury or doing our own research. I think those are just political rhetoric. The two-part reform, Chair, so the Honourable Mautwe may not be aware, being new to the committee, that was the issue that COSATU raised in May 2020 with Treasury. It took some time to convince Treasury. SCOF had extensive hearings in 2020. Honourable Dion George made also similar proposals as well. Took some time, more time than we had wanted to convince Treasury, but we're glad in the end, in 2021, we had managed to find each other. And of course, more discussion had to take place on further reforms. But I think, Chair, the fundamental is we have 1st of September implementation achieved. Now, that's a progressive thing. You can already see billions of rands have flowed out into workers' pockets. It's not perfect, yes. There's limitations, yes. But for a clothing worker to receive 30,000 rand, that's an achievement. That's about 5 months' salary for a clothing worker in some instances. The workers get paid in clothing just about 4,500 a month. To see other workers getting relief, paying off debt, that's a victory. Chair, we think there's a need for 5 further discussions on the two-part reform. One is on the tax rate, could it be less painful for low-income workers? 2 is that can we allow workers to transfer from the vested pot, the existing savings, to the new preservation and savings pot to enable them to get additional relief to pay off debt. When a worker loses their job, can they have full access to the preservation pot to save the home, take care of the family, etc.? Can we allow workers to look at the issue of education loans? And I think Honorable Mato also raised an important point, which we have raised in our engagement with Treasury, with colleagues who are CISA, NEDLAC, and so on. We need to empower the FFCA to be able to set caps on administrative fees, what pension funds can charge. We've seen the average pension funds charging about 350 for the two-part withdrawals. But we have seen some pension funds abusing it and charging amounts of 650, etc. So that's the issue we think it'll be important to empower through the law the FFCA to set a cap, because clearly there is some profiteering which is not acceptable. On the issue of the default payment of pension funds, which is basically theft by employers in the public and the private sector, FFCA, annually kind of shows these employers, about 4,000 or so, large in the security, cleaning sectors. There's a need for PESIDA, the Security Regulatory Authority, to do some work. But also we need to empower FFCA beyond just simply reprimanding them to have real concrete powers. It also chairs a task for the NPA and police to also do action, because it's theft, it's fraud, it can't be acceptable. But we've been amazed, Chair, that in the more recent discovery with the two-part pension reform, one of the hidden benefits of it is that workers are now no longer just simply accepting at face value what's on their salary slip, because they can withdraw once a year or the 30,000 once off. They go and check with the pension funds how much is there, and many workers have been shocked that employers have pickpocketed them. It is not just simply, Chair, example of municipalities in the Free State or Northwest misbehaving, the usual delinquent suspects. We've been amazed, Chair, that even in the Western Cape and KZN, municipalities have also been defaulting. So I was quite shocked, Chair, that Saldanha Bay municipalities is listed amongst them. So there is a need for real action. We have asked for an urgent meeting with NEDLAC, with Treasury, FFCA, CISA, COGTA, SALGA, etc., the PESIDA, because we need to deal with it. Chair, if we don't deal with it collectively, this, I think, Chair, will lead to violence. You can imagine a worker who's drowning in debt. He has hopes of withdrawing 30,000 rand, whatever it might be, from a savings pot, only to find out the employer has been stealing. And one can imagine that situation will become very ugly very quickly. It could even be violent. So, Chair, I think it's a crisis. We have to deal with it collectively. We can't afford just to simply normalize such theft. It's unacceptable and really needs to be dealt with quite ruthlessly, Chair. So I think from our side, we'll push a NEDLAC, but I think also be wonderful, Chair, and critical if Scott can also say we need to put some action there. Lastly, Chair, on that point, we also have had an engagement with the Ministry of Labour, and they're also now going to, as part of the Labour Inspectors 10 tick points, that they go and check on inspections. They also now need to confirm pension funds are being paid as well. And that'll be also a useful boost. And as well, we hope the Minister of Labour's commitment to increasing labour inspectors from 2,000 to 20,000 over the MTEF period will also help materialise, because that also have a significant boost as well to defending workers' rights. But Chair, I hope I've answered the questions, and I hope I didn't take too long. But thanks, Chair. Thanks, members.
Thank you, Comrade Metu. WHO.
Hello, good morning, good afternoon. Thank you very much for giving me the floor. I'd like to respond to a few of the questions that were posed to WHO's response. So the proposal for sugary drinks is really based on the fact that the tax has not been adjusted for over a couple of years, and with increasing inflation, or ongoing inflation, the tax is being eroded, so its effect is being eroded. It doesn't have the same effect it has had when it was first introduced, and also it has an impact. It has an effect on revenues that are also losing in real value. The question on the effect of the tax on consumption, so the evidence is there. There have been many systematic reviews that have been done, showing evidence that consumers are sensitive to price changes in sugary drinks. There's a lot of evidence also from Mexico, the UK, and we can share, we'd gladly share, we have a couple of documents that provide a summary of this evidence. So we'll make sure to follow up on that. I'd like also to note, for example, in the case of Mexico, the evidence has shown that the tax has had a higher impact in consumption on lower income groups, so they reduce their consumption to a greater extent, meaning also the expected health benefits will be greater on lower income groups. On the question of illicit trade and excise tax, so of course we acknowledge that excise tax is one element that can encourage illicit trade, but the benefits from an excise tax increase on the health of population is so important that you cannot sacrifice the impact of this policy on issues of illicit trade, especially when we know that tax administration is really the key to controlling illicit trade and is really the most impactful policy to control illicit trade rather than foregoing tax increases. On the issue of equity, for tobacco, similar to actually sugary drinks, but the evidence is much more vast and strong because tobacco has been taxed for decades, so the evidence is longer term. We know that lower income groups, again, they're much more sensitive to price increases. So when a tax increases, they will reduce their consumption of tobacco products more. And we know also that the burden of disease, especially non-communicable diseases, which are many of them are due to or are associated with tobacco use, the poor bear the most of the burden of those diseases. So if they reduce their consumption, by reducing their consumption also to a greater extent compared to higher income groups, they also benefit more from the health perspective. So tax increases actually are considered a pro-poor policy because it benefits mainly lower income groups. On the question of electronic cigarettes and the proposal that was not specific to, as specific as it was for tobacco, sugary drinks, and alcohol, it's because they are very low to begin with. So the tax incidence is very low, and we didn't want to propose because I think stepping up to the same level of conventional tobacco products, especially cigarettes, will take time. But starting from, by considering already to increase those taxes to a greater extent than the tax is increased on cigarettes, will help push them up at same levels of cigarettes. And of course, we welcome more tax increases on alcohol, given the devastating health and socioeconomic effects their consumption has. So more than 10% is better than 10%. We acknowledge this. Thank you very much.
Thanks, WHO. Sapua.
Thank you, Chair. Just one of the committee members asked to specify the date for the interim stopgap measure around Section 23M and a date that it must be effective. So we request that in order to protect tax-exempt entities such as pension funds and untaxed policyholder funds of insurers, that 1 January 2024 be the effective date of that interim stopgap measure, wording that was proposed by SAPOA. Thank you.
Thanks, Sapua. Back to honorable members. Do you have follow-up questions? Just to ask a question here. I think it's old Moshual. I can't remember who else. This issue of global, you call it global, what, tax? And you are raising very serious issues and as to how it is going to impact the taxpayers. Can you elaborate a bit? What impact will this global tax have on your sector, insurance sector? And as I'm saying, I can't remember which other stakeholder has raised this issue.
Chair, can you hear me?
Yes, please raise your hand through the platform.
Yes. I can't see my name up, but it's Chris Beneke from ASISA. We raised the issue of the globe minimum tax and its impact on policyholders. The globe minimum tax is really an attempt. I'll just give it a little bit of background because I think that in context, because I think that's what you're asking for, Chair. The globe minimum tax is a tax that's being proposed, I think, at the G20 level, and it's an attempt to ensure that large multinationals and effectively pay a 15% rate of tax on their corporate profits in each and every jurisdiction in which they operate. So that's the philosophy behind globe minimum tax. Now, South Africa, as I understand it, has signed up to the globe minimum tax proposals. The detail of how this tax would work has been laid out in OECD commentary, and the South African Globe Minimum Tax Bill, which is the draft bill, was presented or published around the time of the budget, and I understand from National Treasury that a revised bill may be drafted in due course. But that draft bill just sets out the bare bones of the tax and the broad principles that we're going to follow in this country. But a lot of the detail surrounding how the tax would work, you have to go back into very detailed, dense, and voluminous OECD commentaries. And when we as a CISA went through those commentaries and tried to figure out how this would impact the policyholders, I stress the policyholders, not the shareholders, the policyholders of large insurance companies that would be impacted by this tax, we found that there could be additional tax payable by policyholders as a result of the implementation of this tax. And the reason that this comes about is that where an insurance company, which has obviously got large policyholder base, invests in investment entities, and those investment entities could be offshore entities, or they could even be South African collective investment schemes or unit trusts, that those standalone entities in which they invest and in which they have substantial investment stake, those entities could be subject to this 15% global minimum tax calculation. And the result is that the large insurance companies in this country that are all going to be subject to this global minimum tax, they could be subject to this additional tax on effectively investments held on behalf of policyholders. And those policyholders are range from pension funds, non-profit organizations, annuitants, right the way through to men and women in the street who've got endowment policies with large insurers. So it's potentially got fairly wide-ranging ramifications. Now, we being a CISA, amongst others, engaged with National Treasury over the last few months on this. They have in turn engaged with the OECD. And last week, there was probably a four-way engagement involving National Treasury, SARS, the OECD, and a CISA. And the OECD acknowledged that based on their current guidelines, this is a potential problem for long-term insurers in this country. Now, what the OECD has undertaken at that meeting is they would revert with some potential guidance or potential leeway as to how these rules could be loosened a bit in the South African context, and that guidance or leeway is going to be given to National Treasury. And National Treasury, it is then hoped, will incorporate that guidance either in a I don't know whether it's going to be in an EM or whether it's going to be in some sort of interpretation note or whether it's going to be in the draft bill even, to attempt to alleviate the impact of this tax on policyholder returns. Chair, I'm happy to take further questions, but I thought I'd give that as the background.
No, okay. Thanks, Asisa, for that explanation.
Please, pleasure. Chair, it's quite technically complex. So I haven't gone into all the detail, but it's really, we're highlighting the impact of this global minimum tax on policyholders, policyholder returns in South Africa. We stress we're not objecting to the impact on shareholders of life companies. We're concerned about the impact on policyholder returns. Thank you.
Okay, thanks. Treasurer will respond when they come back in the next 2 weeks. Kyla, PwC.
Yeah, thanks, Chair. So we also obviously raised the issue of the GLOBE rules as they are referred to, but in a very different context to which Asisa raised it, although there obviously are some similarities. But maybe just to give a little bit more context to that. So the effective tax rates for purposes of the GLOBE rules are determined largely on accounting principles. So, or that, with some relatively significant adjustments made to that. And I don't think we need to get into all of that. It's far too complex and to concern you with all of that. But the effect of the rules is when it comes to incentives, is largely that certain incentives, and particularly those that have a lower effective tax or lower tax rates. And in the context of South Africa, special economic zones in regime would be one of those. So those are taxed at a rate of 15% as a headline tax rate, but that could actually result in tax rates, effective tax rates of significantly below 15%. Similarly, when it comes to certain other types of incentives, and notably investment allowances that, like has been proposed for the new energy vehicles manufacturing, where those result in additional deductions over and above the actual costs that are incurred in those investments. And that is exactly what you have in the context of what's been proposed for new energy vehicles. Those can result and almost inevitably do result in lower effective tax rates than the headline corporate tax rate, which obviously in the context of South Africa sits at 27%. But if those incentives, the quantum of those incentives is significant enough, it can result in an effective tax rate that falls below 15%, and could almost, in many instances, result in there being no effective tax or zero effective tax rate in the year in which those incentives are claimed. What would then happen under the GLOBE rules is that South Africa, as part of that, are introducing a domestic minimum top-up tax, okay, which would result in South Africa levying a tax that would increase that effective tax rate to 15% in the event that it falls below 15%. So the effect of that is that it could result in in effect, a portion of the benefits associated with that incentive being clawed back and tax having to be paid by the companies in question associated with that incentive, which has actually resulted in the effective tax rate falling below that 15% minimum. So that's the effect of it. And of course, that would actually undermine the benefits of the incentive if all or a portion of the benefit associated with that incentive ends up being clawed back in the form of this domestic minimum top-up tax. Of course, if South Africa doesn't levy that domestic minimum top-up tax, then what will actually happen is the headquarter country would actually end up taxing that as well. So the solution doesn't lie in don't have the domestic minimum top-up tax, because another country will end up levying tax in that regard, and it's even worse scenario that South Africa grants incentive but ends up another country actually then effectively taxing its tax base. So the point that we were making is that Treasury should really reconsider the design around this particular incentive. But what I say, although specific to this incentive, goes for other incentives that may also be impacted. Treasury really should be looking at the design of this and trying to design it in a way, incentives in a way that doesn't result in the undermining of these incentives. And one of the possible ways, and we've alluded to it, is to consider moving towards a refundable tax credit, which is complex, and I don't want to get into that complexity and so on, but that potentially, an incentive being designed in that manner potentially will not result in this unintended consequence, if you like, of reducing the effective tax rate to below this 15% minimum. Let me leave it at that, Chair. Thank you.
Thanks, PwC, for your input. I think we are done with the questions and comments from honorable members until when Treasury and SARS come back with responses, then we'll have another round of engagement. Before I adjourn the meeting, do we have announcements from the side of the Secretariat?
Yes, tomorrow we have a meeting with the Reserve Bank on the annual performance plan and strategic plan. The venue will be M514, 5th floor, Max Building. So we need to be physically present at Parliament.
What time is it? Is it 9 or 10? We've got
10 o'clock.
Okay.
It will be 10 o'clock, sir.
Okay. No, it will accommodate members who stay as far as Pelican, because the bus usually arrives late at Parliament. Okay. Let's adjourn this meeting. We'll meet again with the stakeholders and Treasury in the next 2 weeks, when Treasury will be back. Treasury and SARS will be back with the responses. Then we'll take the process forward from there. Thanks, honorable members, stakeholders, Secretariat, support team, and everybody in attendance. The meeting is adjourned until we meet again in the next 2 weeks, but with the committee members until we meet again tomorrow. Thanks.
Thank you, Chair.
Long live Chair.